Hello, welcome to Local 502, Security Police and Fire Professionals of America Steward Training Program. My name is Thomas Hearn. I am the Vice President of Local 502, and I'd like to welcome you to the video that you are about to participate in. The training class that is to be held today is to assist you in handling your duties as a union steward. For those of you who are viewing this program today, you have either been elected to a union steward position and/or you have aspirations to become a union steward. For that, we thank you and applaud your dedication. To best represent your people, you must be prepared to take responsibilities that other employees are not willing to take. So before we get started today, we'd like to ask you to gather some writing materials so that you can take notes. You can document the things that you will hear today and take them home with you so that they can better apply to representation of membership and/or the processing of grievances. The majority of your responsibilities will be to act as a coordinator between management and your members. Again, we would like to thank you for your dedication, and we would like to present you with the opportunity to act as a steward and do it in an efficient manner. Thank you. The Weingarten decision and the right to representation on the job. The court's guidelines. Under federal and state law, you have the right to union representation when you are called in for a disciplinary interview. To get union representation, however, you must have a reasonable belief that you will be disciplined as a result of the interview, and you must request that a union representative be present. You are also entitled to know what the meeting is about, and you are entitled to consult with your union representative before the meeting begins. The employee must request that a union representative be called into the meeting with management. Keep in mind, management is not obligated to offer you or to suggest to you a union representative. However, during the process of the interview, if you believe that the question or the investigatory process will result in discipline, as seen in Bullet 2, you can stop answering questions and request a union representative at that time. What is a grievance? What types of violation could occur that might constitute a legitimate grievance? First is a violation of the contract. A violation of the contract would be specific to the CBA that you are currently working under. A violation could also be a health and safety issue, a federal or state law violation, an unfair work rules violation, and/or the weakest of these would be past practice. Steward's checklist. A steward should keep an ongoing checklist at all times, as well as notes and a folder to keep those notes in. As you will see in the bullets below, grievances must be processed through the appropriate steps in accordance with the applicable collective bargaining agreement. Keep in mind, those vary from contract to contract. So what is considered appropriate steps under one agreement may not be the same as it would be under another contract. Do you have a notebook or folder in which to keep all of your materials concerning the grievance? Do you have a contract for reference? Grievance forms. Do you have the appropriate forms? Do you know where those forms can be located? For those of you who have a computer, you can download those forms from the SPFPA website. The information and the website address can be obtained from the person who you are working with today during training. Do you have a copy of the grievance? Do you have the grievance history? His or her date of hire, seniority status, previous forms of discipline, attendance records, etc. Answers to both the employer and the union in earlier steps. Statement from the grievant. These are all critical informational pieces that you must maintain. You will need witness statements, if any. However, when you obtain these witness statements, be sure that you make every attempt to get those statements in writing so that you have them for a later time should a hearing result. You will need any maps drawings, diagrams, or photographs. You will need any notes, minutes, memos, or letters relevant to the issue. You will also need requests for information forms submitted to the employer, copies of work rules, regulations, when they are applicable to the specific incident. You will need any previous grievance settlements and/or arbitration awards which may apply. Be sure to list names, addresses, and telephone numbers of all concerned parties. The local president's summary of why the grievance should advance to arbitration. You may submit this in the form of a statement informing the president of what the circumstances are and why you believe this should advance. Be sure to research federal and/or state laws relevant to the grievance. Possess copies of pertinent contract articles that have been violated, and have copies of job descriptions that are affected. As in any investigation, there are some things that you need to know and need to gather. We like to refer to them as the 5 W's. Many stewards use the 5 W's as a guideline to make sure that they have covered all the facts while investigating the complaints. They are when it happened. Be sure to document the date and the time. Where it happened. Be sure to identify those locations. Take photographs if necessary. What happened? What section or sections of the contract were violated? What law, if any, was violated? What correction is needed to settle the grievance satisfactorily? Who is involved? Person or persons with a grievance? Any witnesses? And why is it a grievance? The cause of the complaint. Prerequisites. You have to know the contract. Take time. Read the contract. Be familiar with the articles and sections as they apply. Make sure that the meetings with the employees to handle the complaints are held in accordance with any contract provision that regulate the time and/or location for such meetings. Do not attempt to hold meetings during working hours if your contract does not provide you the provisions to do so. However, in the event that you are going to schedule such meetings, be sure to notify your immediate supervisor and/or labor relations. Develop good listening skills and note-taking skills. If you're talking, you're not listening. Be sure to listen. Listen to all parties. Be prepared to spend the time to get the evidence and testimony to support your case and to refute management's case. Treat all employees fairly and consistently. Keep good records of all transactions, oral and written, that occur from the time the complaint is brought to you until the case is resolved, through a grievance or in arbitration. Know who, when, and how to ask for help. Let the grievant tell his or her story without interruption and take notes. It is also wise at this point to ask the grievant to submit a written statement of circumstances that occurred so that could be referred back to throughout the process. Many times we forget things or we fail to write things down at the time, and it becomes key to the processing of a successful case. Review the grievance description of the case with him or her to make sure you have all the facts. Make sure you get the answers to the questions who, what, when, where, why, and how. Ask the grievant for the names, addresses, and telephone numbers of any witnesses. Ask the grievant to tell you what he or she thinks each witness knows about the case. Record this information. Try to clarify uncertainties about what a witness is prepared to testify to. Ask the grievant to give you all of the evidence he or she has concerning the case. Make copies so that no information is lost. Before the grievant leaves, check one more time to make sure you have all the facts, names of witnesses, and any evidence. Check to make sure that the procedural requirements set forth in the grievance procedure have been complied with. Key considerations include: is the complaint timely? Who should the employee and/or the union representative meet with at the first step? What information must be presented by both parties at the first step? Review the contract provisions alleged to have been violated to make sure they fit the issue described by the employee and that no provisions have been left out. Review the evidence. Go through all of the documents the employee has given you. Make sure everything is dated and signed. Find out if other evidence, rules and regulations, past grievances, arbitration decisions, past practice, documents in the employee's personnel file that he or she may not have that have a bearing on the case as viewed by both the union and the employer. Request documents from the employer as appropriate in a timely fashion and in writing. Be sure to fill out the request for information form that you will find again on the SPFPA website. Interviewing witnesses. Does the witness have direct personal knowledge about what happened, or is his or her knowledge based only on hearsay, secondhand information? Is the witness credible, able to give a reasonable explanation about the events in an honest, accurate accounting, even if this means revealing negative things about his or her record or conduct? Does the witness's statement confirm what the grievant has said, or are there differences and inconsistencies? Does the witness have any reason to be less than truthful in stating what he or she knows about the case? Again, we would like to interject and remind you, this is where a written statement is key. This preserves the statements. If there is more than one witness who knows about the given event, note which ones would be best able to present clear testimony under the pressure of examination and cross-examination at an arbitration hearing. Verify names, addresses, phone numbers, work shift, and location of all witnesses. Make certain witnesses sign and date all statements. Interview all witnesses to determine exactly what they know about the grievance. Be sure to properly and timely complete the grievance form. This includes such items as names, dates, signatures, clear and accurate statement of the complaint, contract clauses alleged to have been violated, and the remedy requested. Refer to the grievance procedure in the contract to make sure the issue the grievant has raised is defined as a proper subject of a grievance. If you are uncertain, ask for help. If the issue is not a proper subject of a grievance, the best thing to do is to tell the grievant and explain how this affects his or her case. Handling discipline and discharge cases. In all likelihood, most of the grievances you handle will involve discipline or discharge. Since management is the party that took the action, the burden of proof is on the employer to show that it has just cause for such action. This means that in an arbitration, management must go first in showing what evidence and testimony it has to support the action taken. A union then responds with the evidence and testimony it has in defense of the grievant and as rebuttal to the case presented by the employer. The duty of fair representation. The union has a statutory duty to fairly represent all of the employees in enforcing the collective bargaining agreement. A union must act in complete good faith. If a union acts in good faith and with sufficient knowledge of the facts, a refusal to arbitrate will not constitute a breach of the duty of fair representation. In general, the courts will not second-guess a union's judgment when a good faith, non-discriminatory judgment has been made. A union has not properly processed a grievance if it fails to undergo some minimal investigation and preparation of employee grievances. The union is not required to be right in its decisions. Do everything you can to fully learn all necessary and relevant facts. Interview the grievant. Interview key witnesses. Keep the grievant informed as to the status of the grievance. There are 7 key tests for just cause. The just cause concept is difficult to pin down, since it presents a cluster of issues and consists of many different elements. Different arbiters will emphasize different elements. Arbiter Carol R. Doherty has devised a 7-question test to summarize the elements of just cause. The authors explain that a no answer to one or more of the questions means that just cause either was not satisfied or was seriously weakened. There are 7 commonly accepted tests for just cause. These are: if a rule is alleged to have been violated, was the rule reasonable? Reasonable rule or order: was the employer's rule or order reasonably related to the orderly, efficient, and safe operation of the employer's business? And was the performance properly expected of the employee? Was the grievant given adequate notice that the conduct complained about was improper? Did the employer give the employee forewarning of possible or probable consequences of the employee's disciplinary conduct? Was the alleged offense sufficiently investigated? Did the employer, before administering the discipline to an employee, make an effort to discover whether the employee did, in fact, violate or disobey a rule or order of management? Was the investigation fair? Was the employer's investigation conducted fairly and objectively? Was the misconduct proved? At the investigation, did the judge obtain substantial evidence or proof that the employee was guilty as charged? Did the employee receive equal treatment with all others who have committed a similar offense? If not, were there any mitigating circumstances? Has the employer applied its rules, orders, and penalties even-handedly and without discrimination to all employees? Was the penalty appropriate for the offense committed? Was the degree of discipline administered by the employer in a particular case reasonably related to the seriousness of the employee's proven offense and the service record of the employee? In closing, we will discuss the National Labor Relations Act. The National Labor Relations Act, NLRA, was enacted by Congress in 1935, known as the Wagner Act. There were many violent confrontations between workers trying to form industrial unions and police or private security forces. The National Labor Relations Act, the NLRA, created the National Labor Relations Board, what is now referred to as the NLRB. Union membership reached 35% of the workforce. Industrialists and other business opponents sought to weaken the act. They succeeded in 1947 with the passage of the Taft-Hartley Act. In 1959, Congress imposed further restrictions on the unions in the Landrum-Griffin Act, designed for the reporting and disclosure of certain financial transactions of labor organizations. 3 most important sections of the NLRA are Section 7, 8, and 9. Section 7 is the heart of the NLRA. It defines protected activity. Employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid and/or protection. Section 7 also protects union activity. In addition to organizing, it protects workers who take part in grievances, on-the-job protests, pickets, and strikes. Section 8 defines employer and union unfair labor practices. 5 types of employer conduct are made illegal: employer interference, restraint, or coercion directed against union activity; employer domination of unions; employer discrimination against employees who take part in union activities; employer retaliation for filing unfair labor practice charges or cooperating with the NLRB; Employer refusal to bargain in good faith with union representatives. Section 8 also prohibits union unfair labor practices, including failure to provide fair representation to all members of the bargaining unit. Section 9 provides that unions, if certified or recognized, are the exclusive representatives of the bargaining unit members. It prohibits the adjustment of employee grievances unless a union representative is given an opportunity to be present. It also sets out union selection procedures. Usually within 30 days, the agent prepares a report for the regional director, who determines whether to issue a formal complaint against the employer, dismiss the charge, or defer the charge. Deferral in Collier Insulated Wire Company, dated 1971. Everyone will receive a copy of a Steward handbook and a handbook guide for handling grievances. You will find on page 6 of that guide the following. Under Section B, you must monitor the contract, keep accurate overtime records, study the contract so you have complete knowledge of its provisions as well as state and federal laws that are applicable. Know the International's Constitution, bylaws, and local bylaws. Thoroughly understand and comply with the rights given to the union and limitations imposed by the labor agreement pertaining to the union and the employees covered by the agreement. Know the grievance procedure. In particular, be aware of the time limitations for processing grievances at the various steps in the procedure. Failure to meet any one of the filing deadlines could mean loss of the case. You, like a supervisor, should get to know each employee you represent personally. Especially with a new employee, you should take the initiative in becoming acquainted and should make sincere effort to gain the employee's confidence. You should be aware of how the company and union have interpreted particular sections of the contract in previous arbitration cases. Arbitrators view past practice as an important factor in contract interpretation. Before you present a grievance case, you should ask yourself the following. Do I know all the facts? Do I know all the names and titles of the people involved? Do I know the dates and times involved? Am I avoiding snap judgments? Am I basing my decision on facts, not gut reaction? You should remember, you have much to gain by cooperating with the supervisor in eliminating the causes of grievances. You should realize that the supervisor has a job to do, and sometimes this will bring you and the supervisor into disagreement. Both parties, however, have an obligation to promote good relations. As a local union representative or steward, you must avoid favoritism. You must try to understand the grievance point of view. Set a good example at work. Avoid playing union politics on grievance matters. Avoid making unwarranted promises to grievance or members. Keep the grievant informed as to the status of his grievance. Avoid becoming unreliable, uncooperative, and antagonistic in your dealings with the company and the union, and realize the importance of your decisions. You must keep a complete set of records showing the grievance issues, the employee or the employees involved, dates, and disposition, as well as any other pertinent information. This record keeping is very, very important.
Hello, my name is Commissioner Rick Queer. I'm a mediator with Federal Mediation and Conciliation Services. Our agency was created by Congress in 1947. We are third-party neutrals, not part of the Department of Labor or the National Labor Relations Board. Our role and mission is to promote and develop sound labor management relations. Our services include collective bargaining negotiations, grievance mediations, and training for labor and management and skills for improving workplace relationships. Both the company and the union have agreed to use mediation as a step prior to determining on whether to proceed to arbitration. This process is voluntary and prepaid for by tax dollars. Mediation is a supplement, not a substitute for the grievance procedure. A mediator is not an arbitrator and does not make a binding decision. The ultimate goal is for the parties to retain ownership of the final outcome by a mutual resolution with the assistance of the federal mediator. Both the union and management will sign a grievance mediation agreement, which includes specific requirements to the mediation. Mediations are private. Non-parties may attend with permission of the parties and consent of the mediator. Sessions are confidential. Statements made and documents created by the parties during the process are confidential and are not discoverable or admissible for any purpose in any arbitration or judicial proceeding. The mediator's notes are destroyed after the session, and the mediator will not testify in any form about the proceeding. Mediations are informal. Rules of evidence do not apply. No recordings will be made. The mediator has no authority to compel a resolution and will not issue any written recommendations or conclusions. The parties agree to hold the mediator harmless of any claims of damages arising from the mediation process. Thank you.
What is happening is a meeting between an employee and Chief Steward in preparation for an investigatory meeting with management as a result of an employee allegedly sleeping at his post. The next step is the Chief Steward assisting the employee in preparation for his investigatory interview with management. The steward needs to gather all pertinent information concerning the incident and proofread any written statements. He will pay close attention to the grievance handling guide and follow it closely. As a result of the investigatory interview, management has determined the need to meet with the employee to impose discipline. Keep in mind, management is not required to grant union representation at a disciplinary meeting. As a result of the employee's action, the employee was terminated. Now that you have had an opportunity to observe an actual scenario, are you prepared to represent your fellow employee? Did you gather the information necessary to ensure that you can follow the grievance procedure correctly, ensuring a request for arbitration or mediation? Remember to use the SPFPA Guide for Handling Grievances. Your coworkers are counting on you. I'd like to take a few moments to discuss contract negotiations. It's the responsibility of unit officers to assure contract mediation notices are filed in a proper and timely manner. That normally is 60 to 90 days prior to the expiration date of your current bargaining agreement. Make every effort to gather proposals that are reasonable and applicable, that they may be presented in a professional manner. Thank you for your participation. This will assist you with your responsibilities as a union representative.